Welcome to Marx 313. In February 1844, Marx published two articles in the Deutsch-französische Jahrbücher, the German-French Annals, which he and Arnold Ruge edited in Paris. The first was titled An Introduction to a Contribution to the Critique of Hegel's Philosophy of Right, and the second was titled On the Jewish Question. The first article Jean Hyppolite referred to as a first communist manifesto. The working class, what Marx called the proletariat, burst forth onto the scene for the first time. Praxis, understood as practical activity in the form of revolutionary action, became a categorical imperative. Marx called for radical revolution in Germany by force to overthrow social conditions that, he wrote, debase and enslave ordinary people. And this all followed necessarily, Marx wrote, from an understanding and criticism of Hegel's philosophy of law and the state. The second article on the Jewish question called for human as opposed to merely legal or political emancipation. Political revolution, though necessary to overthrow a feudal regime, was not viewed as sufficient to produce real emancipation because it merely empowered people to pursue their private egotistical self-interests. Even a human rights framework like the Declaration of the Rights of Man and of the Citizen of 1793 was inadequate to fully emancipate people from the yoke of servitude. What was necessary instead was a social upheaval that transforms self-interested individuals into members of a shared community. Together, these two articles in the German-French Annals in 1844 push Marx beyond the legal remedies that he had proposed in his 1842 articles on the thefts of wood, in which we discussed last time at Marx 213. There, you will recall, Marx called for a legal settlement based on an internationalist customary right of the poor, universal as to the class of poor people in all countries because of their condition in the social order. But by contrast, in these 1844 articles, Marx recognizes the thoroughgoing political and social nature of the struggle and turns instead to the working class and to social revolution for the realization of human emancipation. So from Marx's juridical writings in 1842, then we turn now in Marx 313 to his political writings on the state and the true nature of human emancipation. At Marx 313, we will read and discuss Marx's 1844 articles with the philosopher and political theorist Jean-Louis Cohen of Columbia University, in conversation with a commentary on Marx's On the Jewish Question by the French political philosopher Claude Lefort. A former Trotskyist and co-founder with Cornelius Castoriadis of the journal and social movement Socialisme ou Barbarie, Socialism or Barbarism, that was in the 1950s, Claude Lefort became a staunch critic of the Soviet regime and an expert on questions of totalitarianism. In an article published in 1980 under the title Politics and Human Rights, Claude Lefort returned to Marx's article on the Jewish question to discuss the rise of human rights discourse within dissident movements in the Eastern Bloc. So our guide to these materials will be Jean-Louise Cohen, who's the Nell and Herbert Singer Professor of Political Theory and Contemporary Civilization in the Department of Political Science at Columbia University. She's written numerous books on the topic and articles, including Class and Civil Society, The Limits of Marxism, Marxian Critical Theory. She's co-authored Civil Society and Political Theory, and authored Regulating Intimacy, Globalization and Sovereignty, and most recently published Populism and Civil Society. In conversation with Claude Lefort's essay, Professor Cohen will actualize the import of Marx's 1844 texts for our current political situation. Now, in this short introduction, let me provide some background on Marx's 1844 articles and on the influence of those works on critical legal theory as well as some context for the discussion of Claude Lefort. The debate over the status of human rights and over rights discourse, I will argue, offers the perfect point of entry to imagine, with Lefort, what he calls new modes of thought and action, new modes of critique and praxis, really, centered on values of cooperation and democratic self-governance. Let me start then with a little bit of background. A few months after the publication in the Rheinische Zeitung of Marx's articles on the thefts of wood, which you'll recall was in October-November 1842, as well as some other polemical articles on proposed reforms to Prussian divorce law and other topics, the Prussian authorities decide, by decree dated January 21, 1843, to prohibit the Gazette, effective April 1, 1843. Marx, who was its editor-in-chief, steps down. He steps down on March 18, 1843, citing in his words, quote, "the present conditions of censorship." At the time that he steps down, Marx was already developing plans to edit another publication with Arnold Ruge from Paris, which were to be called the German-French Annals. It is about then, in March or April of 1843, that Marx began working on a close exegetic analysis and critique of a portion of the subsection on the state of Hegel's Philosophy of Right, published in 1820. At the time, Marx was 25 years old. He had moved to Kreuznach to spend time with his fiancée, Jenny from Westphalen, Jenny. They were at the summer residence of her mother in preparation for their wedding. They would actually marry there in Kreuznach on January 19, 1843. And Marx was doing research in political theory and history and trying to prepare articles ahead of time for possible publication in the German-French Annals. It's believed that Marx spent the summer of 1843 at work on his critique of Hegel's Philosophy of Right. Now, Marx had had the idea for a critique of Hegel from an earlier time. In a letter to Arnold Ruge dated a year before, in March of 1842, Marx had expressed his intent to engage in a detailed critique of Hegel's Philosophy of Right. He explained it this way to Ruge. Another article, which I also intended for the Deutsche Jahrbücher, is a criticism of Hegelian natural law, insofar as it concerns the internal political system. The central point is the struggle against constitutional monarchy as a hybrid, which from beginning to end contradicts and abolishes itself. Res publica is quite untranslatable into German, he wrote. So this project to critique Hegel's Philosophy of Right is the work with a slightly different emphasis that Marx would conduct during the summer of 1843 at Kreuznach. And after completing this long exegetic work on Hegel's Philosophy of Right, Marx synthesized the resulting argument into an article which he wrote during the period September 1843 to January 1844. During that time, in October-November 1843, Marx goes into self-imposed exile in Paris, and there he begins editing, along with Arnold Ruge, the Annals. So Marx publishes his synthetic article under the title A Contribution to the Critique of Hegel's Philosophy of Right, Introduction. He publishes it in February 1844. Earlier, in autumn of 1843, he'd also been writing another article on the Jewish question, which developed themes from his critique. And that article was also published in the same issue of the Annals in February 1844. So let me give you some background and explain the introduction to the critique of Hegel. Marx's article on Hegel is a call to revolution in Germany. Marx advocates for the radical overthrow by force of the social conditions that oppress ordinary German people. Marx calls for total human emancipation through the dissolution of society and the universalization of the working class. And this follows logically and necessarily, Marx argues, from an analysis and criticism of Hegel's philosophy of law and of state. Marx's argument proceeds in 3 steps. First, Marx affirms and pushes further Feuerbach's critique of Christianity. Second, Marx criticizes Hegel's philosophy of right using a Feuerbachian method to invert the relationship between the state and civil society. And third, Marx resolves the criticism of Hegelian philosophy by turning to praxis, here revolutionary, practical activity. So let's take the steps one at a time. The first step is laying a foundation with and going beyond Feuerbach. So the starting point is Ludwig Feuerbach's philosophical maneuver in The Essence of Christianity, which was published in 1841. Feuerbach's maneuver reversing the relationship between the earth and heavens. Marx begins his analysis where Feuerbach left off. He starts at the point at which human and social inquiry are focused entirely on the secular realm and are no longer projected onto religions or onto the heavens. The reader gets an immediate feel for this. The very first clause of the first sentence of the introduction to the critique of Hegel reflects this point of departure. He writes, "For Germany, the critique of religion is essentially completed." Right? Without doing so explicitly, Marx is invoking Feuerbach's name, and he makes clear that Feuerbach's critique is the very foundation of his own philosophical and political critiques. Now, in the introduction to Marx 113, I spelt out in detail Feuerbach's critique of religion. Suffice it here to simply reproduce 2 lines from the 3rd paragraph of Marx's introduction itself. 2 lines which succinctly summarize Feuerbach's argument. Marx writes, "Man makes religion. Religion does not make man. Religion is, in fact, the self-consciousness and self-esteem of man, who has either not yet gained himself or has lost himself again." It's in this context that Marx famously refers to religion as the opium of the people. So the point of departure is Feuerbach's critique of religion and his method of philosophical inversion. But already at this stage, Marx pushes Feuerbach's critique a bit further. Beyond the critique of religion, Marx argues that the critical impulse must now take as its object and task the critique of law and politics, of the earthly realm. In other words, Feuerbach's critique of religion is not an end point, but a new beginning for the necessary critique of the earthly realm. And this, Marx contends, is the job of philosophy and history. Or as Marx writes, it's, quote, "the task of philosophy which is in the service of history." Thus, Marx marshals Feuerbach not only to eliminate all questions of religion, to secularize all political debate, to get rid of all otherworldly considerations, to make the world atheist, and to turn our attention onto social conflict. He also turns Feuerbach's method onto what remains, namely human relations in all their social and political forms. You remember Feuerbach had limited himself to understanding and critiquing human self-alienation in its religious forms. In other words, the ways in which humans alienated themselves and their human essence by projecting all that into the heavens. Marx now wants to apply that inquiry onto the way in which humans alienate themselves in their human relations. In this sense, Marx aspires to do to the human realm what Feuerbach did to the heavenly, to unearth the ongoing conflicts and struggles of humans in society, to reveal or render conscious everything that is going on in society, not to dictate from above or to impose ideas or projects onto others, but to expose the ongoing struggles and alienations taking place today in society. As Marx writes, the fundamental task of philosophy in the service of history is, quote, to unmask human self-alienation in its secular forms. And he spells it out this way. Thus, the critique of heavens is transformed into the critique of the earth, the critique of religion into the critique of law, the critique of theology into the critique of politics. You see, of course, how Marx here is turning Feuerbach's method onto the secular realm. Now, this reflects the ambition that Marx had expressed in his famous letter to Arnold Ruge from September 1843, setting out his vision for the German-French Annals. That famous expression, of course, is a ruthless criticism of everything existing. In fact, that letter to Ruge, which was published in the same volume of the Annals as the introduction in February 1844, helps understand this first step of the critique of Hegelian philosophy. In that letter, Marx explains that the purpose of the journal is to help people understand what they are going through consciously, to raise their consciousness about present reality, to dispel illusions and clarify reality. We only show the world what it is fighting for, Marx writes. The reform of consciousness consists only in enabling the world to clarify its consciousness, in waking it from its dream about itself, in explaining to it the meaning of its own actions, he writes. Now, in that task, Marx explicitly builds on and goes beyond Feuerbach's critique of religion to demand a critique of the political state and human affairs. It's only there, within the political sphere, by contrast to the religious sphere, that Marx will be able to locate all social truths, social needs, and social struggles. As Marx writes, just as religion is the catalog of the theoretical struggles of mankind, so the political state is the catalog of its practical struggles. Two things follow. First, admiration for Feuerbach and his critique of religion, and a certain borrowing of the Feuerbachian method, as we will see in step 2. It's no surprise that Marx sends Feuerbach a copy of his introduction, along with a cover letter dated August 11th, 1844, which I had discussed in the introduction to Marx 1:13, that expresses his respect and love for Feuerbach. The second thing, of course, is the logical necessity of turning next to the critique of the political state and of law. So that takes us then to step 2. Step 2, criticism of German politics and philosophy of law and the state, and the inversion of the relationship between the state and civil society. Now, at this step, Marx does something interesting. Instead of taking on German politics directly, Marx decides to focus instead on what he calls its copy, namely German political and legal philosophy. And he decides to take on its copy, German philosophy, in its most pristine form, namely Hegel's philosophy of law and the state, as reflected in Hegel's 1820 teaching manual, which he used to teach his students, and which was called The Fundamentals of the Philosophy of Law, or Natural Law and Political Science in outline. This is the text that we usually refer to as Hegel's philosophy of right. Marx sidesteps German politics So he sidesteps the reality of German politics in a lengthy, caustic aside because he says it is so backwards on his view. He describes the current German condition as grossly out of step with other European countries, such as France or England. Germany has experienced no modern reforms, no revolution, and yet it has nevertheless endured the functional equivalent of a counter-revolution and a restoration. In fact, it has experienced a restoration without a reformation, a counter-revolution without a revolution. The present German regime, Marx writes, is an anachronism. He writes, a flagrant contradiction of universally recognized axioms, the nullity of the Ancien Régime revealed to the whole world. There's this passage where he anticipates the opening line of the 18th Brumaire of Louis Bonaparte about history repeating itself. You'll remember it. In the 18th Brumaire, it's about the history repeating itself first as tragedy and then as farce. Well, here, anticipating that, Marx dismisses the German present, so the German Ancien Régime, as comedy. He writes, history is thorough and passes through many phases when it conveys an old form to the grave. The final phase of a world historical form is its comedy. And with that, Marx dispatches current German politics and decides to focus instead on German political philosophy. The reason is that, by contrast, German political philosophy captures the modern moment. It's a proper target of criticism for Marx because it is so current and actual in the world. In France, politics may capture the moment, the political struggles, the political situation. But in Germany, it's the philosophy of law and the state that is really the locus of present-day struggles, and that also is very actual. It's in the philosophical domain that the Germans are up to date. As Marx writes, we, by which he means Germans, are philosophical contemporaries of the present day without being its historical contemporaries. German philosophy is the ideal prolongation of German history. And it is here at this juncture that Marx would have done all of the work of his full and unpublished contribution to the critique of Hegel's philosophy of right. Again, that long exegetic work commenting paragraph by paragraph on Hegel's philosophy of right, which he ultimately never publishes as is. In his introduction, though, Marx only hints at this larger work. He merely gestures to it, enough to suggest to the reader that Hegel's theory of the modern state bears internal contradictions and imperfections that reveal the internal struggles within society, or what he calls the damaged condition of the flesh itself. Here, Marx borrows the Feuerbachian method of inversion to reveal the conflicts and the self-alienation within society. Marx performs another one of these inversions, turning Hegel on his head or putting him right side up. And this is what he argues. Instead of the state being the foundation for civil or bourgeois society, as Hegel had argued, it's instead civil society that is at the foundation of the state. Now, Marx only gestures at this in his introduction. He had laboriously done this work in the full critique of Hegel's philosophy of right. He intimated that he would publish that larger work, the critique, but leaves it for later, never returning to the full manuscript. He only hints at the substance in the introduction. He develops it a bit more in his article on the Jewish question, And then the following years, he also develops it in his Paris manuscripts, the economic and philosophical manuscripts of 1844, and his manuscript with Engels, The German Ideology, which he writes in 1845 from Brussels. Frederick Engels had explained the thrust of his critique of Hegel in Engels's book, Ludwig Feuerbach and the Outcome of Classical German Philosophy, which he published in 1888. And that gives you a good sense, really, of the work that Marx was doing in the critique. Engels writes, "The state, the political order, is the subordinate, and civil society, the realm of economic relations, the decisive element. The traditional conception to which Hegel too pays homage saw in the state the determining element, and in civil society the element determined by it. Appearances correspond to this, as all the driving forces of the actions of any individual person must pass through his brain and transform themselves into motives of his will in order to set him into action, so also all the needs of civil society must pass through the will of the state in order to secure general validity in the forms of laws. That's the formal aspect of the matter, the one which is self-evident. The question arises, and Engels says, however, what is the content of this merely formal will, of the individual as well as of the state, and whence is this content derived? Why is just this intended and not something else? If we inquire into this," Engels writes, "we discover that in modern history, the will of the state is on the whole determined by the changing needs of civil society, by the supremacy of this or that class, in the last resort, by the development of the productive forces and relations of exchange." So that is the work then at the second step that Marx is performing in his critique of Hegel. But now we turn then to the third step, which is the turn to praxis. So Marx argues for a break from the Hegelian theory of the state, but not from philosophy itself. Rather than turning his back on philosophy, Marx proposes a different solution, to actualize philosophy in praxis. In short, Marx exclaims, you cannot transcend philosophy without actualizing it. And that actualization takes the form of revolutionary, practical activity. So this is the third step in his argument, and perhaps the most important. It's the call to practice, to praxis. Here, Marx is explicit. There is only one means to resolve the contradiction of Hegel's theory of law and the state, and that one means is practical activity. Praxis serves as the pivot for Marx's argument. Praxis is what resolves his criticism of Hegel's philosophy and gives place to his own political philosophy. Now, Marx has in mind a radical praxis, a revolutionary praxis, the use of material force, both tangible and theoretical, insofar as philosophy becomes a material force once it seizes the masses, as Marx says. Marx defines radical in radical praxis as to grasp matters at the root. And invoking Kant, Marx speaks of a categorical imperative to revolution. He writes specifically of, quote, the categorical imperative to overthrow all conditions in which man is a debased, enslaved, neglected, contemptible being. So Marx calls for a revolution in Germany. He writes, a revolution that will raise Germany not only to the official level of modern nations, but to the human level, which will be the immediate future of these nations. In this, Marx is indexing the theory of human emancipation that he develops on the Jewish question, and prefiguring the idea of communism that he will expand on in the Paris manuscripts of 1844, and then, of course, with Engels in the German Ideology in 1845 and the Communist Manifesto in 1848. As for how this revolution might occur in Germany at the time, Marx imagines only one answer: the proletariat class. The proletariat consists of the industrial workers, the poor, and what he calls the ongoing victims of serfdom, of feudalism. The proletariat alone represents the class in society that has a universal and universalizable character, according to Marx, because it is wronged by everyone and has no particular interest or titles to anything. In the introduction, the argument becomes somewhat abstract. At this point, Marx is still trying to weave a philosophical justification for the transcendent role of the proletariat with his analysis of practice. He writes of the proletariat class. So this is Marx writing, and here's where things get a bit more abstract. He writes that the proletariat class is a class in civil society that is not of civil society, an estate that is the dissolution of all estates, a sphere of society having a universal character because of its universal suffering, and claiming no particular right because no particular wrong but unqualified wrong is perpetrated on it. A sphere that can claim no traditional title but only a human title. A sphere, finally, that cannot emancipate itself without emancipating itself from all the other spheres of society, thereby emancipating them. A sphere, in short, that is the complete loss of humanity and can only redeem itself through the total redemption of humanity. The proletariat, then, as this passage makes clear, is the only class that can produce a revolution by universalizing its condition. And it's on this note that Marx ends the article, calling for a fundamental revolution in Germany that would universalize and thereby abolish the proletariat class and simultaneously actualize philosophy. He writes, "The head of this emancipation is philosophy, its heart is the proletariat." So that's the introduction to his critique of Hegel's philosophy of right, published again in February 1844. Now, let's turn to the second article we'll be discussing today on the Jewish question. Professor Gene Cohen will discuss and analyze on the Jewish question at Marx 313 in conversation with Claude Lefort's commentary and argument in his 1980 essay, Human Rights and Politics. Let me here just give you a little background to help the reader, and I'll offer just a few thoughts about the article here in this short introduction. Published simultaneously with his introduction to the critique of Hegel, Marx's article on the Jewish question makes two additional arguments. First, that the liberal political framework of rights, and liberalism more generally, can only secure a limited form of freedom for individuals to pursue their private interests. And second, that beyond a political revolution, which may be necessary to overthrow a monarch, what is needed is a complete social transformation that would bring about human emancipation from private needs and self-interest and allow humans to live their true human essence in full community. The first argument nourished important strands of critical legal theory, including critical race theory in the United States. The second argument anticipates a tenet of Marxism, Leninism, Marxist-Leninism, articulated, for instance, in Lenin's April Theses, namely that a first revolution, or what is generally referred to as a bourgeois revolution, overthrowing the sovereign power of a ruler, that a first revolution like that can only achieve the limited end of enacting a bourgeois civil society, and it must be followed by a second revolution that takes power out of the hands of the bourgeoisie and places it in the hands of the people. Let's review these arguments more carefully, but first let me set the stage. The occasion for Marx's article on the Jewish question is a debate over the legal status of Jewish people in Germany and more broadly in Europe at mid-century, mid-19th century. This debate was referred to on the continent as the Jewish question. During the French Revolution in 1791, all French Jews were granted citizenship and afforded civil rights. That model was debated widely. In two studies published in 1843, the left Hegelian Bruno Bauer took the position that Jews should renounce their Judaism and others their religion as well, in order to achieve a secular state and political emancipation. As Marx writes, summarizing Bruno Bauer's argument, Bauer demands, on the one hand, that the Jew should renounce Judaism, and in general, that man should renounce religion in order to be emancipated as a citizen. Now, Marx criticizes Bauer for posing the Jewish question through the lens exclusively of political emancipation and religion, and for not asking the question of what type of emancipation they should be pursuing. He criticizes Bauer for mounting a critique of the Christian state and not of the state more broadly. So in effect, he pushes the debate to the question of what kind of emancipation people should be striving for. Marx writes, quote, "The question of the relation between political emancipation and religion becomes for us a question of the relation between political emancipation and human emancipation." So Marx reformulates the Jewish question in broader terms, namely in terms of the relationship between religion, political, and human emancipation. And this reformulation of the Jewish question is helpful for purposes of this seminar, because it will allow us to let go of the specific questions surrounding Judaism. It will also allow us to bracket the controversy over Marx's anti-Semitism. The second part of Marx's article on the Jewish question has been the source of great controversy, because Marx there uses Judaism as a stand-in for capitalism and equates the culture of the Jewish people with huckstering. In our seminar, we will not address that second part of the article and set aside for another time the question of Marx's anti-Semitism. Instead, based on the reformulation of the Jewish question that Marx operates in the first part, we will focus on the broader questions concerning, in Marx's words, the relation between political emancipation and human emancipation. And this is fully consistent with Marx's argument in the first part of the article. In fact, he makes this move away from religion very explicitly through a comparative analysis of the resolutions of the Jewish question in Germany, France, and the United States. This leads him expressly to set aside the theological questions, to set aside questions about Judaism, and in the process to set aside Bruno Bauer with them, and to deal only with the political stakes. As Marx writes, quote, "Criticism then becomes criticism of the political state. And at this point, where the question ceases to be theological," he writes, "Bauer's criticism ceases to be critical." So, as reformulated, Marx's inquiry leads him to develop two main theses, both grounded on his critique of Hegel's philosophy of right. Grounded, that is, on the idea that the state is not the rational culmination of the family and civil society, as Hegel argued, but instead that the state harbors and enables all the internal contradictions within civil society, such as religious identities and social conflicts. Political emancipation, in this sense, does not lead to the rational administration of life by the state, but to a situation of social turmoil, as civil society is liberated in a way, but then racked by the conflicts of private interests and and religious conflicts and all forms of alienation that take place in civil society. As Marx writes, anticipating his Paris manuscripts, what prevails in the so-called Christian state is not man, but alienation. Okay, so let's look at the first thesis then in this article on the Jewish question. And the first thesis has to do with the inadequacy of human rights. The first thesis is that the distinction between civil rights, so the political rights of the citizen, and human rights, for instance, the Declaration of the Rights of Man, is an inconsequential category difference, that both types of rights presume a liberal framework of individualized and egotistical interests, and both types of rights are inadequate to the task of true emancipation. The idea is that all of these rights are whether we call them civil rights or political rights or human rights or the rights of man, right, boil down to rights of an egotistical man, of man, as he says, separated from other men and from the community. He writes, "None of the supposed rights of man, therefore, go beyond the egoistic man as he is, a member of civil society, that is, an individual separated from the community, withdrawn into himself, wholly preoccupied with his private interest, and acting in accordance with his private caprice. The only bond between men is natural necessity, need, and private interest, the preservation of their property, and their egoistic persons." So this first thesis represents Marx's critique of rights, and more broadly of liberalism, namely his critique that the framework of rights serves only to promote individualism and self-interest. Liberal political theory, understood as the priority of rights over visions of the good, simply ensures competition between individuals' egotistical self-interests. It does not create a community of shared interests. Here, too, Marx is engaged in a Feuerbachian move of inversion, this time with regard to the relationship between liberty and individual rights. Marx argues that the framework of human rights is upside down. It defends political arrangements to protect the individual's right to pursue their narrow self-interest. Marx considers this an error, what he calls an optical illusion, an inversion of the proper relationship between means and ends. The end, he argues, should be humans living in their fullest potential, not their narrow self-interest. And that notion of humans' fullest potential, of course, was captured by the Feuerbachian idea of species life or species being, which was intended to capture the human essence, which is recognizing and being part of a human community. Marx's argument inspired a long tradition of critiques of political liberalism, ranging from communitarian or civic republican critiques, for instance, Michael Sandel or Frank Michelman, to multicultural critiques, to even to Marxist strands of critique of political liberalism. It would also motivate a critique of rights at the heart of critical legal studies and critical race theory, which I'll come back to in a moment. Now, the second thesis is the need for human emancipation. So, this distinction that Marx draws, this main distinction between an individual pursuing their self-interest on the one hand, or individual human or human beings achieving their human essence as members of the human community. This distinction undergirds Marx's call for human as opposed to merely political emancipation. Political emancipation through political revolution achieves a change in political sovereignty, for instance, the end of monarchy, and with it the end of feudalism. But, Marx argues, that political transition from feudalism only liberates people to pursue their private interests, whether it be their religious beliefs, their private property, or their merchant interests. In the process, it unleashes conflict and competition in civil society. So political revolution, though necessary to end autocratic rule, is not sufficient to emancipate people. What is necessary instead, Marx argues, is what he calls human emancipation. And he defines human emancipation as humans achieving genuine membership in the human community, not as individuals merely pursuing their interests and personal welfare, but as people who are community-oriented in all aspects of their lives, or, as Marx concludes, in his everyday life, in his work, and in his relationships. And it's on this note, then, that Marx concludes his article on the Jewish question, calling for a radical, revolutionary form of human emancipation. Let me talk now about the debate over the critique of rights that was spawned really by Marx's article. Marx's article on the Jewish question gave rise to significant debates over the place of civil and political rights in society and also in Marx's thought. Some critical thinkers, like Stephen Lukes, were adamant that Marx's writings were simply incompatible with any form of civil or human rights discourse. Other critical thinkers, like Justine Lacroix and Jean-Yves Pancher, proposed ways to reconcile Marx's emancipatory vision with the tradition of human rights. Still other critical thinkers sought to extend Marx's critique of rights further. Let me speak about that tradition of trying to extend the critique of rights further. Marx's article became a touchstone for the critique of rights developed by the critical legal studies movement in the 1970s. Duncan Kennedy, one of the founders of critical legal studies, summarizes the main elements of this critique in chapter 13 of his book, A Critique of Adjudication. In that chapter, titled The Critique of Rights, Kennedy recaps the genealogy and main arguments for the CLS critique of rights, critical legal studies. He discusses how critical legal theorists, or what are called crits, began to lose faith in rights, as it became clear to them that rights arguments always reduced to policy analyses, to balancing tests, and to veiled political assertions. Duncan Kennedy described what he called, quote, the manipulability of legal rights reasoning and of its reduction to balancing tests. And he argued that, quote, once it is shown that a legal case requires a balancing of conflicting rights claims, it is implausible that it is the rights themselves, rather than the subjective or political commitments of the judges, that are deciding the outcome. Duncan Kennedy also demonstrated how rights discourse can easily be co-opted by conservative movements, something we've witnessed since the 1960s with states' rights back then, through the 1990s with victims' rights, for instance, to the present with gun rights or the rights of the unborn. In his work, Kennedy specifically traces and compares the critical legal studies critique to Marx's Critique of Rights from 1844. Now, another movement, critical race theory, developed its own unique critique of rights. The critical race theory movement itself emerged in part from dissatisfaction with the civil rights framework and with civil rights litigation. A central argument of critical race theory was that the civil rights remedies tend to reify the idea that racial discrimination is a problem of individual actors rather than a broader structural problem. Civil rights litigation identifies specific actors and pursues relief against them, such as a racist police officer who has unjustifiably killed a black motorist, or a racist landlord who has unjustifiably excluded a black tenant. But those litigation strategies do not adequately address the underlying or the real harm, which is not the individual actor, but the broader social system that reproduces forms of racial hierarchy. So, affirmative action programs, many of which actually are no longer constitutional because of conservative rights discourse, but affirmative action programs tend to justify relief based on narrow historical exceptions to a liberal political framework of merit. But that reasoning, they argue, merely bolsters the idea that American society is otherwise governed by merit and is racially and culturally neutral, when in fact it's shot through with racial, gender, and other hierarchies and forms of domination. On critical race theory's view, a civil rights framework serves to mask the thoroughgoing racialized nature of society. Now, others as well developed critiques of rights in line with Marx's writings. In the international human rights context, Sam Moyn, a scholar at Yale, developed a related critique of rights. Moyn argued that the framework of human rights served to undermine and co-opt more ambitious leftist projects like socialism or more radical liberalism. Moyn also argued that human rights institutions counterintuitively facilitated or enabled more inhumane conditions, such as endless wars, by rendering warfare more humane, or at least supposedly more humane. In his work, Moyn formulated a leftist critique of the ascendant international human rights paradigm. Another international critical legal scholar, Karen Engel, argues that international human rights discourse in general has become increasingly punitive over the past few decades. In the mid to late 20th century, human rights tended to be used more as a shield to protect individuals who were being persecuted by states. Amnesty International's campaigns focused on protecting dissidents and political prisoners. Since the beginning of the 21st century, though, Karen argues, human rights organizations have increasingly focused on the fight against impunity and the prosecution of people for human rights violations. Engel refers to this as, quote, the turn to criminal law in human rights, and she documents it in several articles and book chapters, such as A Genealogy of the Criminal Turn in Human Rights and Anti-Impunity and the Turn to Criminal Law in Human Rights. Engel critiques this development, arguing that, quote, the movement's focus on criminalization has narrowed and distorted its view both of human rights harms and of possible remedies for them. Essentially, she argues that the shift has reinforced the attention to individualized versus collective harms and stunted the potential of other political responses to injustice. Now, in general, these critical legal theories are aligned with Marx's critique. They tend to be more pragmatic than Marx. They're not derived from a critique of Hegel. Instead, they argue for the counterproductivity of rights discourse, in fact. Counterproductivity either because the language of rights is ineffective and collapses into policy analysis and political argumentation, or because it's positively counterproductive in that it undermines more progressive movements and is easily co-opted by conservatives. By contrast to these critical theories that are aligned with Marx's critique, Claude Lefort's writings on human rights offer more of a challenge to Marx. So let me turn now to Claude Lefort and his debate over human rights. Claude Lefort directly engaged Marx's article on the Jewish question in an essay he wrote in 1979 titled Droits de l'homme et politique, Human Rights and Politics. Lefort published the essay in February 1980 in an annual review titled Libre, Free, Libre, politique, anthropologie, philosophie. So it was a review in politics, anthropology, and philosophy. It was a review he founded in 1977 with Cornelius Castoriadis, Miguel Abensour, Pierre Clastre, Marcel Gauchet, and others, Maurice Luciani. A former Trotskyite, Lefort had founded in 1946 with Cornelius Castoriadis a political movement within the Internationalist Communist Party in France. A couple of years later, in 1949, Lefort broke with this, which was this Trotskyist International Communist Party of France, and he co-founded with Castoriadis a journal called Socialism or Barbarism, a journal that would last from 1949 to 1967. He would intermittently be associated with the journal Socialisme ou Barbarie, eventually founding other journals and becoming an expert on totalitarianism. Socialisme and Barbarie ou Barbarie was itself an anti-Stalinist and anti-Trotskyist endeavor, generally favoring worker councils, and that, at least through Lefort, became very supportive, strongly supportive of the uprisings in the East Bloc. Now, by 1980, when Lefort is publishing this article, Lefort is a directeur d'études, so a chaired professor at the École des Hautes Études en Sciences Sociales, the EHESS, in Paris. He is involved in the publication of the annual review, Libre, founded in 1977, which is publishing writings by authors such as E.P. Thompson, Marshall Salins, Louis Dumont, in addition, of course, to the editors, Castoriadis, Abensour, Clastre, and Gauchet. He has just published a book on Alexander Solzhenitsyn titled Un homme en trop, a man too many. That was published in 1976. And he's a staunch critic of the post-Stalinist Soviet regime and supporter of dissident movements in the East Bloc. It's in this context that he published his article, Human Rights and Politics, in that annual review, Libre. Actually, I have a copy of it here. So it was published in this volume right here of Libre, 1980, and it's the first article in the volume. He would also include the article then in L'Invention démocratique, a book he published, a collection of works he published in 1981, which focused on the questions of totalitarianism and democracy. All right, a few words then about the article, Droits de l'homme et politique. And Gene Cohen will analyze this article closely. Here, I just want to give you some background and share a few preliminary thoughts for anyone who is not familiar with the article or is reading it for the first time. And some of these thoughts I hope to develop during my comments on Professor Cohen's detailed presentation. So, reading Lefort's article as a foil to Marx's 1844 article is very salutary, because Lefort's article presents one of the most compelling historical challenges to Marx's position. It presents what we call in jurisprudence the hard case, perhaps the hardest case, a situation where human rights discourse is very legitimately being deployed against communism. Now, of course, it's against a Soviet-style totalitarian communism in the wake of the outright repression and crackdowns of social movements in Hungary in 1956, in Prague in 1968, in Poland in 1970. But still, it's a situation where human rights discourse is being leveled against a communist regime. Now, Lefort is writing, evidently, at a very different historical juncture than Marx, and in a very different political context than American critical legal scholars. In those other contexts, rights are being deployed as an affirmative strategy seeking progressive change. So in Marx's time, rights were being deployed as a way to emancipate citizens and Jewish persons, right? In the 1970s in the United States, rights were being deployed to promote civil rights and a more egalitarian society. By contrast, in the context in which Lefort is intervening in 1980, human rights discourse is being deployed to protect dissidents within communist countries against forms of political repression, in a political situation where organized protest is dangerous and repeatedly crushed. The reversal of circumstances ambiguates the question of human rights. Lefort sees in the new discourse and struggles over human rights, both within communist countries and within democratic societies, he sees the possibility of a new politics that privileges what he calls social power. After deconstructing the distinction between human rights and bourgeois civil society in Marx, Lefort argues that human rights discourse is promoting a new kind of social force and social vision. He identifies this new relation to politics in the movement for worker self-management, what's called autogestion in France, a movement for worker self-management that's gaining popularity on the left at the time. Lefort mentions several times the worker uprising at the Lippe watch factory in Besançon in 1973-74, which we discussed last year in Cooperism 513 with Etienne Balibar in connection with the documentary about the Lippe factory occupation and cooperative. You will recall that there, in 1973-74, the workers occupied the Lippe factory, but then they began operating it as a worker cooperative. Lefort argues that the workers at Lippe were imagining a new relationship to the political by invoking their rights, in Lefort's words, in the name of their rights. So the invocation of rights, the claim to human rights, is generative of a new political vision. This resonates with the writings of the American legal scholar Robert Cover, who developed an argument about what he called the jurisgenerative aspect of law. It also bears a family resemblance as well to the critical philosopher Sheila Ben-Habib's theory of international human rights as generative of political subjectivities. In her recent work, Ben-Habib argues that human rights discourse creates arguments that can be deployed by social actors as tools in political debate. It allows new social movements by deploying rights, she writes, quote, to empower themselves by introducing new subjectivities in the public sphere, by articulating new vocabularies of claim-making, and by anticipating new forms of togetherness. So this is a different model of politics, Lefort argues, a model of politics that does not seek to create a dictatorship of the proletariat, nor to seize state power. He writes, they are not looking for an overall solution to conflicts through the conquest or destruction of established power. Their ultimate objective is not that famous inversion, which would place the dominated in the position of the dominators and pave the way for the dissolution of the state. Unquote. So rather than that, what he sees here, Lefort, right, rather than trying to seize power, what he sees are strategies aimed at trying to jumpstart forms of cooperation that can support a self-sufficient solidarity economy that is not governed by state power. Lefort advocates for an alternative path. He eschews revolutionary praxis, but isn't content being merely reformist. He embraces instead a more libertaire in French. The idea is it's liberty-oriented, a more libertaire form of leftism that is anchored in the values of liberty and equality and cooperation, solidarity, and autogestion, and that privileges social power. Lefort suggests that rights talk serves as a way to open up this social space. As he explains, he is, quote, trying to catch a glimpse of a dimension of the social space which is generally obscured, unquote. In all this, Lefort positions himself in a very distinctive way. He is fully conscious of his own positionality and explicit about it. He positions himself as someone who is post-Marxist, in his words, no longer satisfied with an analysis in terms of relations of production, someone who is beyond the idea of communism, but someone who is still searching for, he says, new modes of thought and action. Now, overall, my sense is that Lefort's political vision, which is evidently different than Marx's political vision, but Lefort's political vision does not really depend on a human rights framework or on human rights discourse. I think that it's more of a historical coincidence than logical necessity that rights talk arose in the dissident context in the Eastern Bloc and arises for Lefort at this time. Human rights discourse at the time was conveniently packaged to sound politically neutral. But the substance of human rights, I would argue, the content of human rights, is somewhat orthogonal to Lefort's vision of politics. In fact, only a few months after Lefort published his article in Libre, right, the Solidarność, the Solidarity trade union movement, erupted in Poland. He publishes this in February 1980. Yeah, it's published the 5th of February 1980. Libre 7 comes out. In August of 1980, just a few months later, the Solidarity movement erupts in Poland, and it's not so much under the banner of human rights as under the rubric of trade union solidarity. The political vision associated with Solidarność is linked far more, I would argue, or at least if I recall correctly, it's linked far more to a secular philosophical viewpoint. Solidarity movement reflected, for instance, the ideas in the essay Thesis on Hope and Hopelessness, published in 1971 by Leszek Kolakowski. It reflected these secular philosophical ideas of hope, as well as, to some extent, repressed Catholic faith in Poland. Now, this would require a much longer treatment, but the point here is that there are many different discourses, human rights, but many others, solidarity, secular, political discourses that can nourish a Lefortian vision of politics. Let me then offer some thoughts on how to actualize the debate. The central lesson of Marx's conception of history, of Claude Lefort's conception of history as well, of most theorists who read and are influenced by Marx, is that we should not speak in the abstract, but always place our analyses in their historical context and in relation to practice. Claude Lefort in 1980, situated within the European left, was addressing a practice of invocation of human rights by dissidents in the East Bloc. A practice of invocation of human rights by supporters in the West as well. And at that unique historical juncture, rights talk was a weapon, a tool, a strategy, one of the few available weapons at the time. The fact that human rights were presented as non-political was important for their efficacy, for the way that they worked at the time. It was possible to argue that in espousing basic human rights, dissidents were not taking a political position against communism. And similarly, that when others outside the East Bloc were invoking human rights, they too were not taking a position in the struggle between Soviet and American power. It was important to maintain that human rights were not political in the same way as other political arguments or principles that were being deployed in the Cold War were. But that does not mean that rights discourse was not in fact political. It was, deeply so. It represented a political intervention along numerous dimensions. It was protective of dissidents who were challenging communist authoritarianism and being persecuted at the time. It undermined the legitimacy of Soviet power to a certain extent in Soviet-controlled governments in the East Bloc. And inversely, it bolstered Western liberal regimes. It forged a possible reformist agenda in the East Bloc, perhaps paving the way for new kinds of socialisms in the Soviet orbit. It strengthened a growing human rights framework of discourses and practices that would consolidate power in the hands of certain international organizations. It had political effects. It was a political intervention, which is true, of course, of all human rights interventions today as well, when human rights are being leveled against China, for instance, or against the United States. Marx, of course, understood human rights discourse as political, as forming part of a political revolution. He didn't portray them as non-political, but rather as not sufficiently political. They were not sufficient for Marx in the same way that Moyne argues that human rights are not enough. To stop at individual human rights was not adequate, according to Marx, because they did not allow citizens to become fully human members of a shared community. In all of this, though, it's crucial, absolutely crucial, not to reify the rights that are the subject of rights discourse. The rights themselves don't have any agency of their own, and they do not do things themselves. They are only put into effect when people interpret them and enforce them. They are tools for those who can enforce or deploy them. They do not have a fixed or independent meaning. And perhaps this is where Marx's argument falters. Rights discourse, per se, is not necessarily or always self-interested or egotistically oriented. Lefort tried to demonstrate this and make this point using as examples the due process rights surrounding criminal punishment. But the fact is that rights don't speak for themselves. Everything turns on how they are being interpreted, deployed, and enforced. And they don't necessarily have to be interpreted as narrowly self-interested or egotistical. Someone could propose and enforce a right to equality or a right to cooperation that could be very effective in dismantling capitalism. Now, by the same token, this is perhaps where Lefort's argument is not at its strongest. From the get-go, Lefort positioned human rights in a very particular way, very distinctive way. Lefort defined totalitarianism as opposed to human rights. He wrote, Totalitarianism is built on the ruin of the rights of man. So, Lefort identified two central features to totalitarianism. First, a state or ruling party that tries to control all power, and second, a destruction of human rights. Now, if that's the starting point for an analysis of totalitarianism, then human rights discourse is primed to be a valuable antidote, whether or not that's true. But the real question is whether it's worth fighting on the territory of rights. It might be if human rights talk is the only available discourse or a hegemonic way of speaking, And to a large extent, that is what the dissidents were doing behind the Iron Curtain, deploying rights discourse because it was their only or best weapon at the time. And certainly there are going to be times when one has nothing better. A person sentenced to death may have few other options. They may have nowhere else to turn. But there are other times when there may be more effective or resonant discourses. At a political assembly like Occupy Wall Street, for instance, or a temporary autonomous zone, or a zone à défendre like Notre-Dame-des-Landes, an appeal to a shared vision of community, to solidarity, to cooperation may be more convincing or consonant. A lot will depend on one's political ambitions and goals. In a liberal democratic state with progressive values, people may find it most convincing to talk about a woman's right to control her body. In a socialist country, people may be brought to talk about a human right to equality and well-being. In a communist country, perhaps human rights are not enough, but even that would depend on the historical circumstances. One thing feels certain. In a punitive society like ours, it is hard to escape rights discourse. In the United States, in the face of racialized mass incarceration, widespread racial profiling, the death penalty, and so on, it is difficult to avoid invoking the Eighth Amendment prohibition on cruel and unusual punishment. But here's the hitch. That Eighth Amendment is about to get eviscerated. The Supreme Court is angling to overturn the decades-old standard, the progressive standard developed during the Warren Court, the standard of the evolving standards of decency that mark the progress of a maturing society. The court, this new supermajority conservative court, is likely going to roll us back to originalist interpretations of cruel and unusual punishment from 1791. That's precisely the risk, or the fragility of rights. Easy come, easy go, as we saw recently in the evisceration of Roe versus Wade, 50 years after it was enshrined. It's precisely to avoid those risks that some advocates turn to other or additional strategies. Some turn to penal abolitionism. Others turn increasingly to cooperation. Some, like I, have argued to replace the punitive paradigm with a cooperation paradigm. That would avoid reliance on an Eighth Amendment that the Supreme Court is likely to retrench. Perhaps we can avoid the risks of rights talk and imagine instead a society based on cooperation. Meanwhile, though, in my death penalty cases, I have no alternative but to invoke constitutional rights. I have no choice in the matter. Let me conclude. As I write this introduction, I'm simultaneously drafting a lengthy 500-page amended habeas corpus petition for a client who's awaiting execution on Alabama's death row. The entire 500-page pleading is one long series of rights claims invoking the 4th, 5th, 6th, 8th, and 14th Amendments to the United States Constitution. Every page speaks about my client's individual right to due process, to a fair trial, to the effective assistance of counsel, to receive exculpatory evidence under Brady, to suffer just punishment, and so on. It is a litany of rights, and the ones precisely that Claude Lefort mentioned in his 1980 articles as conspicuously absent from Marx's discussion. In the pleading, I have no alternative but to claim violations of federal constitutional rights. The minute my client forgoes those rights claims, he will be executed. It's that simple. If we drop the rights talk, my client will be considered a volunteer and swiftly escorted to the execution chamber. We have no alternative. We can work on the political front. We can try to abolish the death penalty. We can seek clemency. We can work on public opinion. We can try to get rid of life imprisonment without parole. None of which is going to help my client in his lifetime, likely. But regardless of those other efforts, we simply cannot relinquish our rights claims, all the while recognizing that none of the constitutional rights we are asserting have any consistency or substance apart from what the federal judge assigned to our case and later federal appellate judges will give them. There is nothing natural nor essential about those rights. They do not reflect human nature. They are not fixed nor defined ahead of time. They are malleable. Oh, one day here, open to interpretation, very possibly gone tomorrow. Malleable, and we try to shape them. We try to shape new ones or new interpretations. In this amended petition I'm working on, we're now struggling to alter federal court deference to state courts under a new constitutional interpretation from the United States Supreme Court. My colleagues, Jim Liebman at Columbia and Tony Amsterdam at NYU, have a new paper out on SSRN in which they argue that the Supreme Court's radical new case, Loper-Bright Enterprises versus Raimondo, that just came down in last term, upended the Chevron doctrine. You'll recall it got rid of the Chevron doctrine of deference to agencies on the ground that deference to agencies violates the supremacy clause and that federal courts shouldn't defer. Well, they're arguing, and we will be arguing in our brief as well, that should apply to deference to state judicial opinions under the AEDPA standard, under the Anti-Terrorism and Effective Death Penalty Act standard enacted by Bill Clinton in '96, which requires deference to the state courts. So we'll be fighting to create new rights there too, under a new Loper-Bright reasoning. And what does this say about rights? Of course, what it says is that the discourse of rights is a weapon, a strategy, a tool at a given historical moment in a given political context. I'm comfortable with that. In fact, I'm comfortable holding onto those two opposite poles simultaneously, human rights and politics, as Lefort titled his piece. I'm comfortable arguing for the human rights of a client on death row, and at the same time arguing for a horizon of cooperation where rights talk will no longer be necessary. I do imagine a time in the future when the punitive society will be replaced by the cooperative society, by cooperism, by a fully integrated social, political, and economic system governed by cooperation. In a cooperative society, I expect the need for individual human rights will be much less. It might evaporate. Instead, we all will dedicate ourselves to democratic self-governance in every aspect of our lives, in our work, in our housing, in our sustenance, in our food consumption, and in our exchanges, in our banking, in our insurance, in our mutuals. And we will all dedicate ourselves to providing mutual support and aid to ensure that our neighbors have what they need to be fully human. I do imagine a time of cooperation. In the meantime, though, I'm going to interrupt this introduction to get back to work on the amended habeas corpus petition. So let me stop here and let me welcome you to Marx 3:13.